Second call for members. If you can hear my voice, please make your way to the chamber, please, so we can get underway. Thank you.
Let us pray. All-powerful, most wonderful Heavenly Father, we now come into your holy presence through your precious Son, Jesus. We thank you for this opportunity to once again gather and meet in freedom to discuss the functions and operations of our wonderful Cayman Islands. We ask that we as legislators be guided in the discussions, that what we do will be for the best of our people, but above all to the honor and glory of your name. Bless us all, keep our families healthy and safe. In Jesus' name I pray. Amen.
Amen. Please be seated. Good morning, everyone, and thank you all for being here. We are continuing our examination of the government's budget appropriations for the 2020 and 2021 financial years. This morning, we are going to begin by examining the appropriations to the Attorney General, and that will cover several entities or portfolios, including that of the Judiciary, Director of Public Prosecutions as well, and the Office of the Ombudsman. We are quorate, and so we can proceed to do our business, and so I would begin. LGA 1, Legal Advice and Representation in Civil Matters, $2,151,319 in 2020 and $2,237,535 in 2021. Are there any questions? My apologies. We are on page 36 of the document, and in the plan of estimates, it's on page 240. Member from East End, I see you're indicating.
Thank you, Mr. Chairman. Mr. Chairman, I should begin by saying good morning and then ask the Attorney General to bring us up to scratch on the appeal regarding the legalizing of same-sex marriage and where his office stands at the moment in that regard.
Thank you, Mr. Chair, and good morning, and good morning to all honorable members. Mr. Chair, as members will be aware, the Court of Appeal recently delivered its judgment in which it reversed the decision that was arrived at by the Grand Court and essentially confirmed, Mr. Chair, that marriage under the Constitution and by extension the marriage law is confined to same-sex couples. However, Mr. Chair, the court also made what we would describe as a very robust declaration to the effect that because there is no legal framework in place to recognize same-sex relationships, then to that extent the government is in non-compliance with the European Convention of Human Rights and the Bill of Rights. So, Mr. Speaker, the way we are at the moment is that we are negotiating, I shouldn't say negotiating, we are going back and forth with the other side on the issue of cost. Usually cost follow the event, and so the government was successful and would be normally entitled to its cost. But that is a matter that is currently being considered by the court. And Mr. Speaker, I think the Honorable Premier has outlined the direction of travel as it relates to the other issue. And so that is the extent of the involvement of our department. Suffice it to say, Mr. Speaker, that whatever instructions is provided in terms of any drafting of any legislation or any other legal support, the chambers stand ready to provide those.
Mr. Chairman, I wonder if the Attorney General can tell us if any instructions has been issued thus far to his chambers.
For drafting? Yeah.
Drafting and the like.
Mr. Speaker, so as I'm aware, the issue of how to move forward post the Court of Appeal decision, Cabinet has not had a chance to wrap its heads around that aspect of it yet because of everything else that has been happening, and so we haven't had a sort of a formal Cabinet discussion on the way forward as it relates to that yet. And that is how usually we would receive drafting instructions.
Mr. Chairman, thanks. Has there been any indication of any appeals that has, I think the time has expired, hasn't it? Notice of appeals.
To the
I'm
Privy
talking-
Council.
Yes.
Mr. Speaker, sorry, Mr. Chair, no, we have no formal indication one way or the other. I think the period is probably about 56 days or something for them within which to appeal.
56?
So the time hasn't expired yet.
Or
I
the
think
time?
it's about that.
The time is
Don't hold me on that, but it's about there.
by all accounts, i.e. the media, the utterances seems to suggest that there will be some response to the decision, because there seems to be some of these who come here and think that they're going to manage and will not settle for the wishes of the people nor the courts. Utterances like it's a sad day for Cayman. You know how many sad days we've had in this country? And we have persevered. I wonder if they were here when there wasn't any leaf, not one leaf left on the tree. And we became the phoenix, eh? Remind them of that. And remind them of when I was out to sea and my mother took money out of my savings to send overseas to fight. And to fight whom? They need to think about that too. There I was born, here I shall be rested, and my bones bleached. Right in East End, the sand. White Crab will have some feast off me too, but it's got to be in East End. Anyway, be that as it may. With all those utterances, will we be prepared to respond as per the resolution of this, the unanimous resolution of this Honorable House, of this legislature? There was a unanimous resolution for us to appeal
If
to the
necessary.
extent, the appeal extent within our jurisprudence. Will we be responding, because the resolution wasn't to defend, the resolution was to appeal. Will we be prepared to respond accordingly?
Thank you, Mr. Chair, and thank the Honourable Member. I understand him to be saying, in the event that there's an appeal to the Privy Council, whether we would be ready. Mr. Speaker, we're creatures of instructions, the chambers that is. And if it is that there's an appeal to the Privy Council, and we are instructed to resist those appeals, that appeal, I can assure the Honourable Member that the Chambers is in a position to do so. That's it.
Mr. Chairman, is the Attorney General inferring that the unanimous decision of this Parliament is not sufficient instruction, since he is an instruction, he's a creature of instruction. Does he need another one? Let me know now. Let's hear it now.
Mr. Speaker, I'm sorry if honorable member misunderstood what I'm saying, but I'm speaking generally, really. So the House and, by extension, the government instruct the chambers, then certainly we are prepared to do as instructed.
Mr. Chairman, one thing you can't say about this Attorney General is that he exposes his flank. He never does that. Okay? No, I like exposing mine, and I like straight answers. Lawyers are lawyers. Let's get that straight. There's always some side road out, off that mean arterial road. I want to know specifically, how should those instructions come? I recognize that the Attorney General has said, if instructed, I want to know if the previous instructions are insufficient at this time to respond to any appeal that may arise out of this particular case. The instructions were quite specific to appeal to whatever extent it goes, which would mean to the Privy Council and beyond, European Court of Appeal, Strasbourg. I guess I should have included in that motion to also respond with the same vigor as an appeal would take. Respond to any appeals. Do we need to do that by Parliament again, or?
Mr. Chair, what I can assure the honourable member is that this is a sort of a moving target, if you will. And as soon as something else happens, in keeping with our duty, we will advise the Cabinet and this Honourable House. And a position can be taken as necessary. But we certainly undertake to keep the House and, of course, the Cabinet up to date as to what is the next step. As the Honourable Member quite rightly points out, the resolution was to appeal, but certainly we understood that to also include to defend if necessary, whatever flows from that. So we never, for one, misunderstood the breadth, the width, and the scope of the resolution.
Okay, Mr. Chairman, and I appreciate the Attorney General saying that he will keep us apprised of whatever. However, he also said earlier that he believes it's 56 days for the right of appeal to be issued or responded, whatever the case may be. Keeping in mind that 56 days may very well be at a juncture where Parliament is not in session for the provision of immediate response action on behalf of Parliament. How does he propose to inform apprise Parliament, if that is the case. And not if that's the case, in any case.
But Mr. Speaker, the way these things operate is that we would have more than adequate notice. It's not usually the last day before. Well, let me rephrase that. The way how this operates is that they have, I think it's about 56 days, give or take, to lodge their notice of intention to appeal. There's a right of appeal to the Privy Council on their side. Once that happens, then we have time within which to respond. I'm not so sure exactly the amount of days or whatever it is. But it is not that, it's something that happened 56 days and then there's an immediate cutoff period. There's an opportunity for us, who would then be the respondent, to then make our own intervention. And so our position won't be prejudiced at all at the end of 56 days.
Can we get a commitment that Parliament will be notified through writing if we're in recess?
Mr. Speaker, I'm happy to do that. I'm happy to provide that undertaking.
And I know you can't give any commitment of respondents dropping out. But we have had that before. And we know the direction that many would love to go. And there is an old saying that if you're skating on thin ice, the only thing underneath there, it has to be cold water for it to be ice. So I know you can't give any commitment on that, but it is your office that is the respondent, right? It's only your office.
Mr. Chair, and through you, sir, the appellants were the Deputy Registrar and the Attorney General's Chamber. Right.
Thanks.
So in the event of an appeal to the Privy Council, the AG's office, or the AG and the Deputy Registrar would then become the respondent.
Yes, that's what I'm talking about. I hope we don't see any dropping out now. We have come too far. You can only speak for your office, but that office is instructed through here and Cabinet. And I trust that the registrar will be likewise instructed and likewise hold their own, because this office holds much more authority and power to demand and instruct.
Member of Georgetown Central, I believe you had some questions next, and then, okay, you can defer to the member from Savannah. Member for Savannah, please proceed.
Thank you, Mr. Chairman. First of all, I want to say how impressed I was by the young lady sitting behind the Attorney General, Reshma, in her presentation. In her presentation, I mean, she had a grasp of just about everything, and I'm glad to know we have someone like that in Cayman, the job that she done. I want to also thank the Court of Appeal, who took politics, took everything out of this, personal emotions, and responded as is indicated in the European Commission on Human Rights. Same-sex marriage is not a human right. my understanding is about 37 or 40 people, states in the European Union that do not recognize this. But yet we have a gentleman that every time I turn around, he's writing or doing something and criticizing our appeal court. And my question to you, Honorable Attorney General, is this individual has been wandering around all over the world, went to look for the Pope and different ones. I thought he was here at the pleasure of our people. I didn't quite understand why in the first hearing he was sitting there with the petitioners. And I don't know how we can sit down and continue to have someone that has inflicted so much pain on so many of our people in Cayman that have lived by this standard. And as I've said, and everyone knows my stand on this, so I won't go with that. Why are they just rubbing dirt in our face? They know how we feel. And as I've said in my letter to the Compass and others, and on my debate, a lot of our Caymanian families have people with this movement, this desire of living in that lifestyle. But never in my lifetime have I known of anyone to be injured, no one to be harassed. None of the businesses would turn down their services. So I don't know where this alarm is. And what I don't understand is that if we try to defend ourselves, they call it hate speech. Mr. Attorney General, I'm sure you see what's happened in Canada. You see what is happening in the United States. This is my reason for standing up. A little place of 60-something thousand people and you see, as I indicated, once that doorstep is open, what's going to happen to our 4-year-olds in the schools, 12-year-olds, and so on? There is no, how are we going to stop? Is this going to be the same thing that your honorable office will have to defend to the hilt? The rest of, well, you like myself, close to retirement, but whoever take over from you have to defend these things against. You see, if in 2014, when that then government had listened to me, did a referendum on this, we would have took a lot of air out of this, the balloon and what's been going on. It's unfortunate, but I need to know and find out why someone like Mr. Raznovich is still going around bad-mouthing the Cayman Islands, being here, I would assume at the pleasure of the Cayman people, because I don't know if he's working, I don't know if he's got a work permit now or not. It doesn't matter to me, but I need, you need to talk to him, and also to your governor. I thought he was here to govern all the people, not to jump off the ship right away and praise when the first decision was made by the Honorable Chief Justice, uplifting it. Then later on, I think, said he was taking his name off as a defendant or whatever it was. He sent it to govern the Cayman Islands, and the majority of the people that live here don't run off and say, you're doing this and that and next thing without being here for a short period of time, knowing what the beliefs in Cayman is, that has lived and survived 500 years, blessed beyond belief from Hurricane Gilbert, blessed, as my colleague from East End said, when there was not one single leaf left on any tree in these Cayman Islands. You think that happenstance? You think that happenstance? He has warned us. Cayman, wake up. Thank you for entertaining my diatribe.
Thank you, Mr. Chair. Mr. Chair, clearly this is a very passionate issue. And there are a lot of advocates around, people positing their views about what should and should not be, and what the law is. I mentioned in this House on numerous occasions that there are as many opinions as there are lawyers. And so, fortunately, we have a Court of Appeal that has looked at the matter and has provided clarity in terms of the legal position And that is what the judgment does, provide clarity, especially as it relates to Section 14 of our Constitution and Section 2 of the marriage law. And until something else happens, if it does, the current state of the law is now quite clear that marriage in the Cayman Islands is confined to marriage between opposite sex. That is the definition of marriage in the Cayman Islands. Thank you.
Thank you, Mr. Chair. Through you, Mr. Chair. Attorney General, I hope that you can assist me because, like you said, this is a very sensitive matter. And the people that we represent will obviously be listening to the proceedings of this House. And the ruling in this case gives a lot of legal jargon that most people don't fully understand. So I'm going to ask you to try to respond in, I guess, kind of common man terms in respect to what exactly this ruling is actually saying, because I think it's important for us as a country to understand what this actually means. So I want to first just read a section of the conclusion by the appeals court and see if you can, outside of its actual wording, simplify it so people can understand. And under section 116 of the conclusion, it says, as we said in paragraph 6 above, the appellants have finally accepted that section 9.1 of the Bill of Rights required the Legislative Assembly to provide the respondents with legal status functionally equivalent to marriage. Its failure to comply with its obligations under the law in that regard is woeful. Now my question is, what exactly does that mean?
That there's a recognition on the part of the state, Mr. Chair, through you, thanks to the honorable member. There's a recognition on the part of the states that in the absence of a legislative or legal framework that will recognize same-sex relationships, then the government is not in compliance with the convention and the Bill of Rights.
Thank you. Thank you. Through you, Mr. Chair, I'm going to read another section and you can interpret that as well. Under 117, it says, in recognition of the long-standing and continued failure of the Legislative Assembly of the Cayman Islands to comply with the legal obligations under Section 9 of the Bill of Rights, and in recognition of the Legislative Assembly's long-standing and continued violation of Article 8 of the European Union Convention, it is declared that Chantel Day and Vicky Borden-Bush are entitled expeditiously to legal protection in the Cayman Islands, which is functionally equivalent to marriage. Now I want to repeat the last part, functionally equivalent to marriage. Can you give some examples of what is functionally equivalent to marriage so the country can understand what is expected of us?
There are certain basic rights, Mr. Chair, there are certain basic rights that comes with when a person is married. If we can think about some of those at the top of our head, you can add someone to your health benefit, your entitlement to your pension payouts. Some of those are the social benefits, if I might put it that way. And what if we have legislation that recognize same-sex relationship, other relationships, if I might call them those, call them that. In this case, Ms. Day and her partner, they would have been able to do things as if they were a married couple in terms of acquisition of property, health care, provision of health care benefits, pension benefits, all of those things. Would be able to add one or the other to those kind of plans. And so it's some of those sort of basic rights that flows from that sort of a relationship. Section 9 deals with the right to private and family life in the Constitution. And so all the other constituent parts that you would expect a family to be able to do, the legislation or whatever framework we have in place, would guarantee them some of those other basic rights, except that they're not the married couple.
Okay. Through you, Mr. Chair.
May I just add, Mr.
Yes,
Chair,
yes.
that we're moving, the world is moving, and I say the world because we draw our inspiration on some of what we do and for, well, we are part of the global village now. And we have had 2 decisions, I think, in recent times out of the UK Supreme Court, which also now makes it clear that common law relationship ought to be recognized as well, legally. There need to be a framework in place that recognizes common law relationships.
Okay. Thank you. Mr. Chair, through you in, and I'm glad you brought up that because it kind of leads into my next question. Based on the declaration by the appeals court that strongly suggests that the UK intervene if we as legislators don't do our part to address those violations of the articles, what are the options, the common accepted options, maybe in other jurisdictions and the like, that are not marriage that this honorable house can consider?
Mr. Speaker, thanks to the honorable member, and through you, sorry, Mr. Chair, through you, there are various options around, but the most common is legislation called the Civil Partnership Act. I think Bermuda has one. There are some other countries that have promulgated those kind of legislation. It's called different names, but the one most commonly used is Civil Partnership Law or Civil Partnership Act, which sets out those sort of rights, the parameters of those rights. And essentially what it does is allows for the relationship, if I might call it that, to be registered. So it is registered and recognized, and then the rights will flow therefrom. And so.
Thank you. Through you again, Mr. Chair. Can you tell this committee what the United Kingdom structure is with same-sex relations? Do they have, what is their structure there for same-sex?
My recollection, Mr. Speaker, is that years ago they started out with the civil partnership law. I think if some of us will recall Sir Elton John and his partner when they started out initially, there wasn't the right to same-sex marriage, but there was a civil partnership framework that allowed them to enter into the civil partnership, and the relationship was registered by the state. And I think by a process of gradual maturation, if I might put it that way, in 2014, the UK eventually enacted same-sex marriage legislation. So they do have both. You have civil same-sex legislation, and you also have civil partnership framework as well.
Thank you. Through you, Mr. Chair, I'm glad you explained that there's 2 options there, because it leads me to the other question.
Yeah, and as a matter of common law, they now also have common law relationships.
Common law relationships. Thank you, AG. And through you again, Mr. Chair. If for whatever reason this honorable house or the honorable house does not create framework to address the conclusions within the appeal court of the violation of Article 8, there is an expectation that the United Kingdom will intervene by order in council. I'm trying to get an idea of what to expect from order in council to be, and I use this word because this is what most people would refer to it as force on the Cayman Islands. What could we expect? Because I want the country to understand exactly what we're facing is if we don't address this as legislators, what the UK is more mindful to do. I know that's probably a speculative question to ask you, but I want us to realize as a country that is it more likely to be forced to have same-sex marriage, or is it more likely that we will have same-sex unions forced by the UK if we don't address it, or what is your predictions so we we as legislators can understand?
Thank you, Mr. Chair. Mr. Chair, I would not.
Mr. AG, I don't want you walking in those type of scenarios around here. No one I want to be walking in them kind of scenarios of speculating on this, because you don't know what anybody, which side debate anybody's going to wake up on in the morning.
Well, thank you, Honourable Leader of the Opposition. The most I can say is that since the judgment, I have not had any discussions with the UK about any possible options at all. So, unfortunately, I wouldn't be able to say what their thinking would be in the event that they are minded to do anything.
Thank you, AG, and through you, Mr. Chair, I just want to make sure it's clear that I'm not suggesting trying to set you up in any capacity. What I'm trying to have this dialogue is so the country can hear what the probabilities are, because we all have some serious decisions to make in this honorable house. Now, just two more follow-up questions in respect to this area. Do we have any influence through any structured means or through the Premier or yourself or through the Governor to say that if we fail through our Legislative Assembly to find a resolution by way of some sort of legal structure to accept the violations, do we have any way to influence what the ordering council could be? So for instance, we just said that, I didn't want to load you with a question to assume what the UK is going to do, but could we, if the UK was to say, I'm going to have an ordering council, can we influence a suggestion to say, if you have to do that, that can you do not marriage, which they have in legislation, not unions, which they have in legislation, but maybe common law relations, which they also have in legislation? Do we have any influence over their decision is what I'm trying to get at.
Thank you to the Honourable Member. Thank you, Mr. Chair. Mr. Chair, the straight answer is no, we don't. I don't, and I don't think the Premier does. But in the usual protocol, well, I shouldn't say usual, a general protocol, because sometimes there are different approaches adopted. But generally, when the UK is proposing to do anything by way of legislation for Cayman Islands, or whether to extend a treaty or convention to us or anything, they usually solicit our views on the issue, and there would be some discussions as to whether that would be done in this. I really don't know, but generally there are some sort of a discussions.
Okay, last question in respect to this matter, Mr. Chair. AG, you said you haven't had any communications with the representatives of Ms. Day and Ms. Bush, and we know that there's an option for appeal. And I think the Premier did a good job to indicate, obviously by public means, that the government intends to bring some sort of framework, whatever it may be, to this honorable house to remedy the violations. But obviously he also indicated that that doesn't happen until the first quarter of next year. So the principle is that these respondents, or the appellants, apologize, are subject to trusting that there would be a resolution to what is said to be the violations come sometime next year. Obviously that is passing the date of their appeal. Has there been any indications as to an extension of their appeal if they're not happy with the outcome of those structure, the bill that may come to this honorable house? Because I can see their predicament, whereby they may not necessarily want to go to a court of appeal if some resolution may come, but they don't know what the outcome of that bill may be, so therefore they don't want to lose the chances for going to a court of appeal. Is there any way that we can, in the interest of not having to go through another legal battle and costs, either extend or give them level of comfort to say we're trying to resolve this, so don't appeal it, because to continue to battle this is obviously a cost, but we have to if necessary.
Mr. Chair, through you, it's a kind of very difficult question in the sense that the lady, they have very competent lawyers. They do have very competent counsel, I must say that. And I'm sure they would be mindful of any deadlines and the timelines that are required to be met in terms of any appeal. And they would, I imagine, take all necessary steps to preserve their right of appeal, their ability to appeal, the right, of course, if necessary. And I don't know, I suppose if they think it would help, they would certainly reach out to us to see whether there's any sort of a consensus that we can arrive at. But it is, even if the dates are the time is expired, as I said, there's a right of appeal to the Burford Council, and usually it doesn't necessarily follow that there will be a sort of a cut-off period. There are some proceedings that would have to be taken in the local court, deal with security of costs and all those other things. So we would know exactly what is going on, and if necessary, whether any accommodation can be made to preserve their right, if that's what you're asking about. And so we will open to any sort of a discussion with them. But ultimately, it's a matter for the Privy Council, and to the extent that it matters, the local court will appeal here in terms of the direction of travel.
Member for Northside, I think you had your hand up, sir.
Yeah.
Mr. Chairman, while he's thinking, just on the following the last comment, I'm not sure if the Attorney General is aware, but when we as the opposition at that time met with Lord Ahmad, or whatever his name was, he indicated to us that there was no intention of the United Kingdom government interfering in what we decided on those things. So to give my colleagues some peace and thought, hopefully if it went to Privy Council order, that he would at least respect the Court of Appeal decision.
To you, Mr. To you, Mr. Chairman, I just wanted to ask the AG if, in his opinion, a legal structure that created civil unions with whatever we choose to call it, with equal rights as provided in the legal structure of the current marriage law and included common law marriage, would satisfy the directive of the Court of Appeal decision.
If I understand you, Honourable Member, whether the legislation would be crafted in such a way as to reflect those positions.
Yes.
In keeping with good administration, that's a mandate from the Court of Appeal.
Right.
So, as a country of rule of law, we would be required to craft the legislation with those things in mind.
Yeah, and second question. There is a section, I think it would be in the border control law, it used to be the immigration law, where I think it was political and seditious activity could be used as a basis to declare somebody a prohibited immigrant. Can you give us a broad definition of seditious activity? Not good.
Mr. Chair, through you, I couldn't tell the last time I've looked at that. I see the DPP here. I don't know if he can help us, but
Actually, I just
it would
found
be
that
activities aimed at almost bordering on insurrection and destabilizing destabilizing the country, and so
Right.
some sort of insurrection.
And I won't ask you to opine on this, but actually it is in section 120 of the Customs and Border Control Law. 122 says, where the cabinet consider that a person is an undesirable person or that the person's presence in the island is not conducive to the public good, the cabinet may make a deportation order in respect of such a person. Section 120 of the Border Control Law 2018, subsection 2. And I would invite I guess it should be the cabinet and you to consider whether the activities of that fun and name person that has been causing all of these problems rises to that section of the law.
I thought it was an observation, really.
It would be fair to expect the Attorney General to respond individually
Thank you.
unless presented with a specific case and specific charges. But I would invite any member of the public to do what I did with the Jordanian, although I didn't win. But that section of the law allows any member of the public to write to the cabinet detailing the matters that are concerning them as to the operation and the conduct of an individual who's here under provision of our immigration law, and draw cabinet's attention to that and ask cabinet to make a decision as to whether what the person is doing as detailed in the letter rises to the provision of 122, and if it does, to therefore declare the individual a prohibited immigrant.
Member for East End.
Thank you, Mr. Chairman. Mr. Chairman, I do not think that is totally unreasonable because we must control, and Cabinet has the authority to control the behavior of the residents, all those who reside within the borders of this country. Likewise, we see many of our people go to other countries and their behavior may not necessarily be in keeping with peace and good order. And they're usually picked up in the middle of the night when they're sleeping and put on the plane bound for the Cayman Islands. Likewise, we have seen it to Jamaica, to other Caribbean countries. Therefore, it is reasonable to assume that those countries control those who would wish to visit or reside therein. And it is not unfair for us to be exercising those same rights. If we welcome everybody, but if your conducting your behavior is such that it disrupts the harmony and peace and good order of this country, then we need to put you on the first flight, direct flight, out. If there's need to transfer, then we will use the authorities of those countries to ensure you get onto the plane to get to your final and your originating destination. Maybe the time has come for us to exercise the authority that we do have in this country and stop wearing our hearts on our sleeves.
Member for Bordentown West.
Thank you, Mr. Chairman. Through you to the Attorney General. I noticed that the description for this expenditure that we're looking at, it basically says legal advice and representation in civil matters. Just out of curiosity, in the event that government loses a civil case, where are the funds, if any, that government had to pay? Where would those funds be budgeted?
You, it's not there. So usually, Mr. Chair, through you, depending on the amount of the award, whether it's by way of cost or damages, if we represent a particular department, say immigration department, for example, and a decision is made for damages and is over and above a certain amount, which cannot be accommodated in the current appropriation or the existing appropriation, then a submission would be made to Cabinet, and Cabinet would vote 11-5 or something to take care of the award.
Thank you very much, Mr. Attorney General. Through you, Mr. Chairman, to the Attorney General. Just out of curiosity then, and recognizing that this is public funds that we're spending, I notice in many cases that many of the civil cases that we have comes with these non-disclosure agreements. And I'm trying to understand, or what's the thinking behind, because some of these I believe is actually in the public's best interest. At a minimum, for us to know what happened, why it happened, and if needs be, who we should hold accountable. What's normally the thought process going forward? And I think this is something that the Auditor General also raised in terms of some of these cases being basically settled with these non-disclosure agreements.
Thank you, Mr. Chair. It is correct that it is public funds, but the use of non-disclosure agreement is extremely common in civil litigation, or similar type of litigation. And the state is on one side, but there's a private individual who's on the other side. And invariably, Mr. Speaker, for whatever reason, those private individuals would prefer those details to be kept confidential. And in the spirit of a settlement, those wishes are usually respected. Having said that, the Auditor General is always entitled to see those figures, and that office has no problem in seeing them. Where the dispute comes in is whether the Auditor General should be publishing those figures in a public document. And since, like any other office, the Auditor General office is bound by the law. If there is a disclosure agreement which is arrived at and is covered by confidentiality, and in some cases there's a consent agreement to that effect by the court, then the Auditor General's office is bound by that confidentiality as well in terms of any public disclosure and so. But it is a very common phenomenon in settlement of commercial and other civil disputes.
Through you, Mr. Chairman, to the Attorney General, but wasn't a precedent set by a former Auditor General, Dan Duque, when he declared publicly that the confidentiality of the agreement between the government and Cayman Insurance Center on the settlement for Hurricane Ivan did not bound him, and he disclosed it publicly? And he wasn't challenged, to my recollection. So I think the precedent is set that the Auditor General can, in fact, disclose it.
I don't agree that the Auditor General can disclose it. I think the one with Cayman National and the payout from the insurance company might have been a little different, in the sense that that was a payment made by an insurance company to the government. And so, in a sense, that wouldn't qualify as any private party on the other side, really. I don't think we would want to. I don't think the insurance company would properly, in this sense, qualify as a private party. So I can see an exception in those circumstances. But certainly where you have a private individual, an employee, who has a separation package with government, and for whatever reason, and quite understandably in most instances, would prefer those personal details to be kept confidential, then I think it's only reasonable that that be respected.
Then I come back to you. Washington West.
Thank you very much, Mr. Chairman. Through you to the Attorney General. I noticed also that within the description, it spoke about advice coming from both qualified Crown Counsel and attorneys. Just roughly on a ballpark percentage basis, what percentage of the advice is done in-house versus what percentage of the advice is given, I guess, externally or received externally?
Thank you, Mr. Chair. I would say probably about 98% of the advice are done in-house, and probably 2% done out externally.
Thank you, Mr. Attorney General, which then brings me to the next question. One of the things I noticed in the annual HR report 2018, which was published by the portfolio of the Civil Service, is that within the legal profession, within the government, it is one area that is still predominantly non-Caymanian. And I couldn't help but notice that the pay scales that the Crown Counsels and other lawyers within government are on are actually very uncompetitive with regards to what the industry is, because at the end of the day, we're still a financial services driven industry. Lawyers and CPA are still in high demand, and I think at some point we have to accept that we can't create a society where those with money will have a different access to justice or legal representation than those without. The question to you, Mr. Attorney General, is what it is that we can do. I mean, in addition, or if there's a case to be made to ensure that we start actually putting proper pay scales in place to attract and retain Caymanian talent within the civil service, because we can't have a situation where your offices and other places become training grounds for them to go out in the private sector and then use those skills to basically, in some cases, pervert the course of justice, and we have criminals walking the streets because they have just really good attorneys.
Thank you, Mr. Chair. I hear a chorus behind me say, don't oppose that question, please. Mr. Chair, thanks to the honourable member, sorry for the observation. It is true, the average starting salary for a Crown Counsel is $6,300. Well, yes, in some places the article clerks in some of the bigger firms are sort of competing with that sort of thing. But we appreciate the circumstances in which we operate. They're competing dynamics. We have scarce resources, and everybody has to be spread among everybody within government. So even though it is not desirable, not what we would have liked, we do understand the circumstances. And I think over the years, the government has been fairly good in addressing some of these salary disparities. But if we make a comparison with those in the private sector, then it's true, then we're really not comparing apples with apples. It is true that in some countries you have a separate pay scale for doctors and lawyers, people with specialist skills in these areas. And we always make the point that, and I say this with the greatest respect, we always made the point that you can take a Crown Counsel with 5 years PQE and send him or her to one of these ministries, and within a matter of weeks they could do an excellent job as a chief officer. The converse is not true. You can't take the most senior chief officer and send him to the legal department and give him a file after 6 months and ask him to go down to the court and address the matter. So there's clearly a difference in terms of skill sets and so on. But, well, I'm sure there are others who can make that argument, but it is a fact, and so it is true. There's room for adjustment. There's always room for improvement, but we continue to do what we do best, which is the provision of legal advice and legal support to government within the constraints that obtains. Yeah. So.
Thank you, Mr. Attorney General. I mean, just as a ballpark, out of curiosity, if you were to take just because we have lawyers in the private sector and the criminal lawyers I'm talking about in particular who live on legal aid, and if you even take what the hourly rate is for legal aid and compare that to even the hourly rate that we are actually paying our own crown counsels, you literally, as soon as you have someone trained up, they can literally walk out of your office the next day, put a sign up on a door, and go into the legal aid business and literally make 2-3 times what it is that they're making in your office. So the question ultimately is, I mean, looking at it and looking at the stats and going back several years, we realize that this has been a profession that has been predominantly non-Caymanian. And the question then ultimately is, we recognize that pay is an issue, especially with this industry. What is the next step in terms of correcting that? Because ultimately, and I think my colleague from West Bay North had raised the issue, a lot of young Caymanians do take offense when they're actually feeling that they're being prosecuted by quote-unquote non-Caymanians. And it's kind of a stigma that is coming up, and I think is one of the things that we need to kind of start fixing in society. So the question in all of that is like, what do you see as the next step, or what do you think needs to be done? If we have to create a separate scale, then so be it, but we need to fix this problem. What do you see as a solution?
Clearly, it requires further consideration, Mr. Chair, through you. When about 2 years ago, the former DPP and myself, we started looking at making representations to government to creating a separate sort of pay structure for lawyers, and see whether we could find a way to peg that, for example, as is done in some other countries, to peg that to institutions such as the judiciary. Well, certainly for the senior judiciary, I think, so how it's looked at. So we looked at that, and we were hoping to be able to get around to put in some proposals on paper and then approach government to see how well favorably disposed they would be to accepting that. Unfortunately, we haven't gotten anywhere. But it is true, because what has happened, Mr. Chair, through you, I think during my time as AG, I would have articled probably about 26 lawyers over the years, and some of them spent a couple of years with us, but then they transitioned to the private sector because the salary is really just not competitive enough. So they have all moved on, really. And it is difficult to attract and even more difficult to retain young Caymanians within the chambers, because as soon as they get to a certain level of competence, they're poached. And we're not in a position to compete really with that sort of salary. So some reflection and introspection needs to be done. And we will be turning our attention to that along with the Office of the DPP to see how best to try and address this, to come up with some sort of an accommodation which will make it attractive for Caymanians to want to join the department and remain there. Thanks.
Member for Georgetown Central, after which I'll take the vote.
Thank you, Mr. Chair. Mr. AG, I just want to go back, unfortunately, to the same-sex ruling. You may recall that in the motion and my contributions to the motion to appeal the Chief Justice's ruling, I was of the view that we had three options. One, accept same-sex marriage. Two, create civil partnerships or civil unions. Or three, independence. Now, I know those are some strong positions, but is it fair to say that if we as a country are not willing to accept, we as a people are not willing to accept some sort of framework, the only way out is through independence? Is that a fair assessment?
Mr. Chairman, I don't know if I would want to elevate it to that level, really. I am sure in somewhere in between there's some sort of a happy medium that could be struck. While this is not really within my grasp, the independence is an extreme, really. And I'm sure, just speaking generally now, not just as Attorney General, but generally, I think that I would doubt that these are really the only three options. I'm sure there's some other accommodation somewhere in here, some other happy medium that could be arrived at.
Thank you. Through you, Mr. Chair. With the preamble that I just suggested, that if the country does not want any legal framework that has persons of the same sex recognized, regardless of whether it's marriage, regardless of whether it's unions, regardless of whether it's partnerships, if the country decides that it doesn't want any kind of legislation at all with same sex, would it be fair to say the only way out of that, considering that we are a British overseas territory, is by way of independence?
Mr. Speaker, unfortunately, I can't go down that road. I don't remember. It's kind of out of my area of expertise, really.
Member for West.
Mr. Chairman, I think I can safely say this. If this Legislative Assembly does not put in place a legal framework for civil unions within, I'd say, within the first quarter of next year, the United Kingdom government is going to probably, all indications are, introduce or reintroduce, because the Chief Justice had ruled that same-sex marriage was recognized by the legislation. There's no question in my mind, based on my discussions with the governor, that that is exactly what is going to happen. So we can decide, quite frankly, whether we want to shape what that legislation looks like, or we can leave it to the UK and we'll just have same-sex marriage on the same terms as conventional marriage.
Member for East End.
Yeah, Mr. Chairman, I wanted to ask the AG a question, but since the intervention by the Premier, I think I should also say that I know no government can bind another government, future governments, but certainly from the response to the FAC report recently, the FCO made it quite clear that they're not going to step in, but you can't trust that anyway. I appreciate that that cannot be trusted. And I understand that that has been their cop-out. Every time there is something, they love to say, well, we're not interfering. That's domestic matters. And in every instance, since I know, they find some other way of doing it. And I understand that. And whichever government comes in has a different agenda. I would like to hope also, and I hear in the Premier's statement that probably, so there are some uncertainties of what direction they will go, but I would like to hope that despite my opinions of them across the pond, that they would recognize the wishes of the people and the concerns of the people, and not go to the, what we used to call it, the nuclear option, so to speak, directly into the nuclear option of same-sex marriage, if it is that it has, if it winds up there, or they're impatient, or whatever the case may be. So I would hope that that is one of the considerations that they have.
Mr. Chairman, the UK's government's preference is for same-sex marriage. That's what they have. That was apparent for those who read it in the statement issued by the Governor's office following this Court of Appeal ruling. It was apparent also in the Governor's insistence that his office be withdrawn as, or not be an appellant in the case, although they were a party to the original action. You see, it's about, regarding the issue about whether or not one government would be bound by another decisions, what we have in this instance now, which was not the case before, is we have a declaration by our own Court of Appeal that the government is in breach of the Bill of Rights in not providing such a legal framework. And the United Kingdom government is not going to allow that to go on indefinitely. So if we don't address the breach, they will. There's no question at all about that. So I have said publicly, and I've said privately to the governor, we simply as a legislature do not have the time and space to deal with it this year. And I think they've accepted that. But I am as certain as one can be about things over which you have no control. If we do not act within the first quarter, my belief is that the United Kingdom government will.
Mr. Chairman, I used to defer to my good friend, the Premier, in days gone by for legal advice, but I don't know if opinions may necessarily be the order of the day now. Yeah, your opinion versus mine now is not legal advice anymore. Yeah, and you didn't become one. I recognize that too. That's the second time you said that. I believe that it is, as I have also talked to the governor, and I also advise him that this one is a sensitive one for this country, and he must not trade heavily with a big stick on this one, because I know everybody comes here looks to leave a legacy. I would advise that this one does not be considered part of a legacy of anyone, and being forceful because of personal positions It's not a good thing to be. We all know. And they should all know that there are very capable people in here who can represent their people and get the people on their side too. So let's not leave in disgrace nor shame as a result of not being embraced by the very people you are required to govern in your appointments. Mr. Chairman, let me turn to the AG. That's dying cross the bow, you know. That's knocking out the mass. You better look for the sails now. That ain't cross no bow. I don't shoot crossbow, I hit something. Sailboat, the mast is down. Don't be sitting idle in the water, because there's no need for steerage after that. You let me tell Mr. Austin right now, okay, that he does not instruct anybody in here, including yourself as chairman or me as a sitting legislator, more so a senior legislator, about get to the question. He will sit and wait until I do. Thank you. No, I don't do that with anybody in here, not even him as a junior legislator. It's disrespectful, and tell him to cease and desist. I don't do that to the Premier. The Premier don't do that to me. Yeah, well, you just in his category then.
Members, please proceed with your questions.
Thank you. Shut up. Mr. Chairman, I want to go back to the Attorney General with regards to that non-disclosure discussion we were having. And you said that it was usually the request of the other side, the recipient of the cost or whatever. Do we always, considering the interests of the general public, do we always oppose that?
Mr. Chairman, I am not aware of any instance where we oppose the request to do so. I'm not saying it doesn't happen, but I'm not aware of any instance where we have. And
so we acquiesce at their request.
Usually it's in the spirit, as I said, it's in the spirit of a settlement, an agreement. And so that is position, there's compromises on both sides.
Mr. Chairman, I wonder if the Attorney General believes that in the interest of the general public, we should be, I believe in the interest of the general public, we should have that degree of transparency to say what our liabilities have been and whatnot. Don't we believe that we should try to not do this unless it is of grave, it would create grave circumstances if we didn't?
Mr. Speaker, there is a balancing exercise. What is in the public interest is not necessarily, something that the public might be interested in is not necessarily in the public's interest. And so there are two different things. There are some members of the public who clearly would want to know what a separation package that a particular individual received from government. But I'm sure we can all also appreciate the sensitivity of someone who, for whatever reason, is separating from government. And not wanting all and sundry to know exactly what it is that that agreement entails, what it is that they finally ended up with, and so unless there is really something sort of exceptional, some sort of exceptional circumstances that we can think of, it is usual to acquiesce to the request that the amount remains confidential. But as I said, the Auditor General is entitled to see that amount, that figure.
All in favor of LGA 1, legal advice and representation in civil matters for $2,151,319 in 2020 and $2,237,535 in 2021, standing part of the schedule to the bill, please say aye. Those against, no. The ayes have it. Colleagues, I need to let everyone know that I've only just received word that our sergeant lost his father this morning. He passed away. So, very sad news for us. Sarge has left the building to go and be with his family. But I'd like for us to, maybe stand and observe a moment of silence for him and his family, and then we'll offer a very short prayer. Heavenly Father, we pause at this time and a very sad occasion, hearing the news of our sergeant losing his father this morning. Father, we have been struck with so many deaths in our community and even within the halls of this assembly, with family members passing away. Father, these are sad times for us, but we know that you are the great comforter and that time and your presence will heal us all. Father, we pray a special blessings for Sarge and his family at this time as they grieve the loss of their father. I pray, Father, that you will comfort them as only you know how, that they will feel and know of your presence, and that you will help them to bear this burden and to see better days for themselves ahead. Would you comfort them and continue to watch over them at this trying time? Father, help us all too to keep our minds upon life itself, Father, recognizing that it is but a breath of air and can disappear from us and be taken from us at any time. Bless this assembly as we continue in our deliberations this day. We pray in Jesus' name. Amen. Please be seated. We now turn our attention to LGA 3, Law Teaching and Publications, $1,401,728 in 2020 and $1,406,696 in 2021. Are there any questions? Member for Northside.
Through you, Mr. Chairman, I noticed that the full-time certificate number of students is between 40 and 45. Can the Honorable Attorney General say how many of that 40 or 45, whatever it is, are Caymanian?
Thank you. Mr. Chair, if the honorable member could repeat the question.
Through you, Mr. Chairman, under the quantity of LG 83, it says number of students 6, but I would assume that that's an error because opposite PPC completion certificate says 40 or 45. My question is, how many of those are Caymanian?
Mr. Chair, with your leave, may I ask the representative from the law school to assist? State your name.
Ria Minty, Assistant Director of Legal Studies. In terms of our current professional PPC students, we have 5 currently on the professional practitioners course, 3 of which are non-Caymanian and 2 of which are Caymanian. In terms of the overall cohort for the current students that we've got, we have 78 Caymanian students and 18 non-Caymanian, and that's across the board for our LLB, LLM and PPC.
That's your total students, that's not...
Correct. So it's 78 Caymanian and 18 non-Caymanian in total.
Okay, but my concern is how many Caymanians are in the LLB
In
course?
the LLB program, so across our LLB program and LLM is 78.
Caymanians,
Correct.
okay.
Member for Newlands? You finished?
No, it wasn't quite. Can you give me the hours that the law school operates when the classes take place?
So the law school runs from 8:30 a.m. in the morning till 5 p.m. We also have a late library scheme that runs during the assessment windows, which enables that our full-time working cohort to come to the law school, which is open till 9 o'clock in the evening. In terms of classes themselves, they run from that 8:30 in the morning through till now, because we have the LLM, which runs as an evening course, runs through until 7 o'clock, 7:30 in the evening.
Need her to speak more into the microphone. It's not picking up.
So my apologies. That's probably my Welsh accent as well. It's probably...
So the law school operates during the same courses that are offered in the day are offered in the night as well?
No,
Are the same courses offered during the day, offered during the nighttime?
no, that's incorrect. So our day programs are the LLB and the PPC. The evening program is the Masters in International Finance.
Is there any consideration being given to offering classes in the evening time for the LLB so that Caymanians who are working can have access to it? Because not all employers are going to give people time to go to school.
This is something that we've talked about in the past. There aren't any current proposals for that. We try to accommodate for students that are working by having the core classes taught between the lunch hours. So Monday through to Thursday, 12 till 2, or what we call our core session opportunities, so that students who do work on a full-time basis can use their lunch hour plus an additional hour and then hopefully work that back with their employer. Most of the students who are on the course on a full-time program do have very supportive employers in that case.
But my grandma used to tell me it's hard to learn on an empty belly. So, but I guess if that's the only way you can accommodate them rather than doing it in the evening time after they finish work. And your campus is located where now?
The campus is in the same building as previously, so it's in the old CIB Seal building, the 2nd and 3rd floors, just across the way.
Yeah, the reason I ask that is there any thought being given to move it to the community college campus?
Mr. Chair, I can say that years ago there was ongoing discussion about the possibility of relocating the law school to the to the campus down there. There were mixed views about it. There were, well, resistance, but there were mixed views as well, because there were those who, students who liked the opportunity of being able to walk during their lunch period to the current location to do their classes, rather than having to drive down to the university campus. But also there was some issue about assimilating the law school into the university. And there was strong pushback from Liverpool about their brand in that respect. So if it is something that is being offered as part of the law school, the curriculum for the university college here, then Liverpool might have a problem with how that resonates as far as their brand is concerned, and whether it could still be a Liverpool University degree.
I was thinking more in the lines of getting one of the law firms and offering an endowment to the law school, and they put up a nice academic facility on the University College compound, which would enhance the appearance and reputation of both bodies. Because I think if we have a law school that is as good as it is and is recognized as it is, hiding it in a commercial building in town is not conducive to attracting Caymanians who come to the school with 14, 15 O-level passes with distinction.
That's true, but it was also contemplated that it would be part of the, if the honorable member recall, there was some plan to have a dedicated court building somewhere in the halfway point, and one of the proposals was that the law school would be part of that structure. Unfortunately, that fell through.
You need $1 million one?
Mr. Chairman,
Mr. Chair,
if I may, and certainly I don't want to be contrary to the Attorney General, but I must respectfully object to his understanding or because when this subject was brought up, it was the Right Honorable Premier and myself many years ago, and it was never the intent for it to be a part of the community college. It was merely to house it in that school environment, that environment of higher learning, so to speak, but stand apart. Pardon me? You wasn't the Attorney General then? Oh, in more recent times, they're talking about making it part of the university. I ain't supporting that. I am not supporting that. No, I am going to support creating another, the law school institution as a physical, from a physical perspective, up there within the land space that we have available, but not to join the UCCI campus. No. Location was the only reason the Premier and I brought this up many years ago. And Mr. what his name was? Yeah, the one we kicked out of here. Ballantyne objected to it because he wanted absolute control. That's as I understand it and remember it. The Premier is there, he can say. But may I, can I go on? Can I?
You're asking me?
Yeah. Mr. Chairman, can I ask the Attorney General? Yeah. Mr. Chairman, can I ask the AG, how many non-Caymanians have been given dispensation, a special dispensation to to study in this country in law, PPC.
By cabinet. By cabinet?
I thought it was by your office that does that.
No. You're talking about permission, consent from the cabinet to do the PPC and articles.
Yeah,
Yeah.
through you though it's done. Yeah, but on application through the Attorney General's office.
Well, I take the paper to cabinet.
Absolutely.
Yes.
Thank you.
Yeah, but Mr. Speaker, I unfortunately I don't have that number with me, but I can certainly find that and provide the honorable member with the breakdown.
But as I understand it, the last time we had this protracted discussion on this matter, it was that they would have to be married to Caymanian or some connection. Is that the principle we continue to operate on?
Yeah, yes, Mrs. Chair, through you, that's still the criteria. So usually marriage and or some other family connection, but that is still the case.
Like the children of a Caymanian or a permanent resident or something of that nature.
That's right.
Okay. As long as that's what it is.
And in addition to that, it should be made clear that you heard a number there, that was 5? Right. There is no issue at all about them taking places that would otherwise go to Caymanians. Indeed, in fact, we certainly don't have enough people doing the PPC. I'd love to have a lot more people applying for the PPC. So we're running really short as far as the numbers are concerned. So
I don't have a problem with running the course for 5 people because that's way below what I think they're capable of doing.
I want to clarify that these people who receive the cabinet's consent is not taking anyway in a spot from any Caymanians.
No, but eventually it takes spots out in the business community. That's the concern that we have to have without any nexus to this country and the possibility of them. That's a 4-year total course, school plus PPC and articleship, 5 years. But my concern, five and a half years, my concern is you need 10 to get permanent residency, so they need work permit to work in this country then. Yeah, but it further compounds itself, Mr. Premier, in that no foreigner should work here other than the legal service, the Attorney General Office and the DPP with less than 3 years PQE. Now we gone into a different argument. How then do we allow someone on work permit with less than 3 years PQE? It tends to kill itself once you roll the numbers over. Anyway, Mr. Speaker, I know, and I'm not here trying to oppose the school. I want that to be made very clear. What is this vote of 1.4 million is merely as an injection, as what's the revenue compared with this?
Mr. Chair, can I ask the CFO, Tiffany, to clarify first? Yeah. How much we get from fees and stuff? No, make you come and do it. A follow-up, I can't do it. No, but they'll follow up, I can't answer that. You go answer it. Yeah. Let's state the name.
Okay.
CFO.
Tiffany Ebanks, CFO for the Portfolio of Legal Affairs, Office of the DPP, Judicial Administration, and Office of the Ombudsman. Through you, Mr. Chair, if I understand the question correctly, it's what is the revenue budgeted for in terms of law school? For 2020, it is $450,000, and 2021, $450,000.
So that, does that mean it takes $2 million to run it per year?
So with the funding from students and so forth, along with the revenue from cabinet, which is 1.4, then that's how we get the total expenditure of the 1.8.
2 million makes no difference one way or the other. It makes difference to you. But let me say that, Mr. Chairman, before we go on, I want to congratulate Mrs. Ebanks to say that that's the perfect example of a young Caymanian lady who walked into my office as a minister, and I didn't know where she had come from. And when I asked her who her mama was, she immediately understood, and she told me it was Minnie from Savannah. And at the time she came in as a accountant of something of that nature. Because we had deputies, we had other things. And that is 2006. 13 years later, and she carries more portfolios than anybody else. I am extremely proud of you. I wish you well. And hopefully one day it will, she was my everything to me, gave me all the hard time at the time. You know, her and the other one, what her name is? Stephanie, yeah, they're the ones that gave me the hard time. I couldn't do a thing. I couldn't buy a candy for them. Anyway, I thank you for all those years of controlling me, and I wish you well, and I am extremely, extremely proud of you.
Sir, Mr. Chairman.
AG, you should be glad to have somebody of her caliber along with you after I started training her.
Sir, Mr. Chairman.
I am extremely proud of her, Mr. Chairman. She's very capable, very efficient, very reliable, highly professional lady.
Sir, just while we're on the issue of the revenues, I couldn't help but notice on page 381 of the estimates that even though it's budgeted $450,000 for both 2020 and 2021, I noticed in 2018 it was actually $605,000, which was almost 50% higher, and 40% around thereabouts higher than what it is as being budgeted. And in 2019 it fell to $454,000. So just curious in terms of the drop in revenue between 2018 and 2020, if it's driven by, I guess, lower enrollment, or what's driving the decrease, really? I don't want to speculate, but what's driving the decrease in revenues between 2018 of $605,000 down to $450,000 now?
Mr. Chairman, we did leave our last director to assist us, Mr. Mitchell.
you to state your name and position first, sir. Thank you.
Mr. Chairman, Mitchell Davies, Director of the Truman Bodden Law School. In terms of the reduced projected revenues, the Honourable Member is correct in the assumption regarding lower enrolment. The other factor is in recent years we've also had fewer international students, and international students pay approximately twice the local student tuition fee. So it's both those factors, a decrease in overall enrolment and fewer international students.
How much international student pay? Say that?
Is there, through you, Mr. Chairman, to the Honorable Director, is there anything that we can do in terms of encouraging more people? Because one of the things that we had touched on yesterday is where we look at where the scholarship age cuts off, I think at around 35, and recognizing that there are a lot of mature people who in their later years in life would probably want to switch to law. Is there something that we can do? Is there more scholarships that we can give out? Or is there even a scholarship budget at the school for young people coming in? Because most universities have a kind of endowment or something that will pretty much allow something. Or as the member from Northside even mentioned, something as even looking into night classes where we can get more people within the legal profession. Is there something that we can do as a public or as a legislative body to actually help to increase enrollment? Because this is a great school.
Thank you, through you, Mr. Chairman. Thank you very much for that suggestion. We don't have any endowment at present. I think that certainly would be of great value to encourage enrolment from students from perhaps less fortunate backgrounds. We have expanded the number of programs in the last few years, so we do have late afternoon, evening classes on a master's program that we introduced 2 years ago. Master of Laws in International Finance. And we've also tried to develop a more visible relationship with the schools. So we've tried to encourage more school leavers to come, because we noticed in recent years we haven't had many students come straight from school. They tend to be more mature students. So we're trying to look at both ends of the spectrum in terms of going out into the schools, giving presentations, encouraging schools to invite us, include us in careers events, and that is bearing some fruit. We also have a program whereby, as honourable members may be aware, A-level law is taught at St Ignatius High School, and that is taught by Truman Bodden Law School teachers, lecturers. And so again, that helps develop an interest in the law at an earlier stage when they're 16, 17, and a number of those students have started to come through to the law school.
Mr. Chairman, through you to the Director, or rather, sorry, to the Attorney General. I think maybe a year and a half, maybe 2 ago, this House had voted unanimously on a motion that we had brought asking for the establishment of an education fund. And one of the sources that we had looked at were the many companies that had business staffing plans that had within their plans a requirement to basically provide scholarship for Caymanians. Having sat on the business staffing plan board and recognizing that many companies weren't doing that as what was required, the motion actually called for a government to give those companies the option of paying into a fund, because at the end of the day, they still had that responsibility to the people of the Cayman Islands, and maybe from that fund we could actually use funds to basically educate, especially Caymanians, more mature Caymanians that fall outside the scholarship remit. So I think this is something that is really definitely worth, especially looking at what we have in the financial services industry and trying to get more people encouraged. I think this is one avenue that the Attorney General can look at in terms of getting an endowment started for the law school, because at the end of the day, it is incumbent on all of us to make sure that this school eventually stands on its own.
Thank you, Mr. Chair. We certainly will be happy to have a look at it again. I do recall the motion, and I certainly will find a way to sort of see if we can trigger this consideration. Take it on board.
Thank you, Mr.
Member for
Chairman.
Georgetown Central.
Mr. Chairman, I've been waiting a little while. You know. Mr. Chairman, I wonder if the director could tell us what the operating hours are for the law school. What hours are students able to access the building?
Through the chair, thank you for that question. We operate the usual core government hours, 8:30 until 5 p.m. each working day. For the latter half of each semester, we extend the library open till 9 o'clock on 3 or 4 days a week. That's dependent on staff volunteers to supervise it. So it means students will have access to the library and the classrooms until 9 p.m. for at least 3 days a week for the second half of the semester, and it's timed in that way because that's when we're getting towards assessment periods and the students need to spend more time in the library and doing their research.
Thank you. The reason why I asked that question is because would it be possible for, and I know you're probably limited in resource and so on, but students need access to the building physically, not just during exam times, but during other times, and that has been a complaint that's been raised and brought to my attention, is that they basically get locked out of the building after 5 p.m. basically, so they can't really get in to do research and so on. Is there anything that can be done to remedy that?
Through the chair, the issue I think is obviously one of security. We really need somebody from the law school, a member of staff from the law school to be present to supervise library use. We could certainly make arrangements for students to have access to the teaching rooms, which are on a separate floor from the library. And so that would mean that they would have no access to the library but could use the teaching rooms as a quiet area of study. The slight security risk associated with that is a number of the staff, including myself, have their offices on that floor. So if there was nobody there, then particularly around sensitive periods when assessments are forthcoming, there would be concerns about security of exam materials and so forth. So I suppose the real problem is we have 2 floors in the building, so we have limited space. Yeah. As you'll be aware, it's a private building that we lease, that government leases. And we have control over access to it, of course, as the long-term tenant. Mm-hmm. But it is really those security issues which do provide a limitation on after-hours access.
Yeah, and that actually leads to my next question, which is, are there dedicated study rooms for students? Because I understand that there's only the library that's available in that, acquired environment, so it's not conducive to students sitting and discussing and collaborating with each other. Are there study rooms available?
Through the chair, there's no separate study room. We do have quite limited accommodation, quite limited space. There are areas in the library that are designated. They have individual carrels, sort of individual study desks, where the students can study, as well as sort of longer tables where they will study probably with their colleagues. We do have a student common room, which is, I should say, far more well provided for than the staff common room. It's much bigger, and probably 10 students at a time could probably sit in there. So that's an area where they can study with their colleagues, where they can talk and they can discuss things. So that would be the only other common area that the students could use, other than the library, which, as you say, is a designated quiet space.
Okay. And I understand some time ago one of the lecturers actually presented a proposal to start offering a part-time LLB evening class, and I was told that it was backed up by evidence of the demand for that course. Is there any particular reason why it wasn't pursued?
Thank you for that question. Through the chair, we already have a part-time program as a route over 6 years to the degree. The full-time degree takes 3 years. The part-time degree can be studied over 5 or 6. But you're right in assuming that is taught during the daytime.
Yeah.
And really the reason why we haven't been able to pursue that is a staffing issue, because all our staff are committed in daytime teaching. We have the master's program, which has been another staff commitment, which is in the early evenings. And so I suppose it was the priorities that we placed in terms of the teaching that we have already and the programs that we have already, and the fact that we have a limited staff to call on of 9 full-time staff to cover these different courses.
And I guess I'm assuming now then that would probably be the same reason why we haven't implemented the GDL type program of study as well for people who already have university degrees but want to convert to law.
Yes, that is correct. The other factor which is impinged on the decision not to offer a GDL type qualification, frankly, is that I think there's a feeling that it would cut into our LLB provision and would likely mean that a number of the students, particularly international students who tend to come with the first degree, would be able to enroll on an expedited course, which would of course mean less revenue from them for doing so. Yeah. So I think it is a concern that it would probably, depending on how popular the GDL program was, likely produce a downturn in revenue because of its effect on the existing LLB provision.
Last question, really. I know that there are changes coming in how you qualify to become a lawyer in the near future. How are those changes going to impact the operation of the law school from a financial point of view and resourcing and so forth?
I think you're referring to the solicitor's qualifying exam, which is...
Yes.
Yes. I'm very optimistic that's going to have a positive effect on law school enrolment. In brief, the new procedure for qualifying professionally in the United Kingdom is changing from the old procedure whereby you would complete either the bar course, the bar practitioner's vocational course, or the legal practice course, the LPC. It's my understanding that from, I think, 2021 or 2022, the date keeps being deferred, that the new process will be phased in, called the Solicitor's Qualifying Examination, which will be set in 2 parts. The first part will include core substantive law topics, both substantive law and law and practice. And then between SQE 1, that's the first exam, and SQE 2, the second exam, there's a requirement that students take a period of internship in a law firm or work as a legal executive or in some similar capacity, and they must have completed that work experience for, I think, 2 years before they can then enroll on SQE 2, the Solicitor's Qualifying Exam 2, which is made up entirely of skills assessments. Now, the reason I believe that will be attractive and beneficial to the Truman Bodden Law School is that it seems to me it's going to make it very much more difficult for international students from wherever they come from to enroll on the SQE process, because it will mean, amongst other things, them gaining that work placement experience in between the 2 parts of the exam. So myself and my deputy director have been active in trying to engage the law firms recently. We had a meeting with the senior managing partner of Walker's 2 weeks ago. We have a meeting with the senior managing partner of Maples next week, and we're going to speak to as many law firms as we possibly can. And our question to the law firms and the legal profession is, what can we do to make the law school more attractive to you, given the uncertainties of the SQE process in sending the students that are articling with you or that are being funded by you to us as opposed to the UK, because that is a real problem as well, and it also has a big effect on our revenues, that a lot of students are studying in the UK. It pains me to say that a number of them are supported by government scholarships. So they are being supported by government to go to our competitor law schools in the UK, and that has a real effect on our revenues. So in terms of the SQE and the professional practice course, I think it's going to be positive. We anticipate greater enrolment on the professional practice course as a result of the SQE, but trying to also engage the law firms so that we're providing the courses that both the Maples and the Walkers firms want, but also the smaller firms. We're conscious of the fact that not everybody is going to be an international commercial lawyer, and we need to have that core of provision for local practice as well. So it's trying to meet all those objectives and sandwich them into a 9-month program.
Yeah, thank you. I was going to mention the practical work experience component, because we've had concerns, or as legislators, that some law firms may want to cherry pick students and want to take those who they may see as potential lawyers in the future with their firm, or they may reject students. I don't know how we're going to approach that, but if it's part of their formal education requirements, we're going to have to negotiate strongly with these law firms to ensure that, and I think that's where the Honorable Attorney General will come in, that they play their role and do their part in helping to educate and train the students, because without that practical experience, you can't become a lawyer. So it's going to be a sensitive issue, but it has to be resolved quickly.
Georgetown Central. And then we're going to go to the member for Northside.
Thank you, Mr. Chair. I just, through you, Mr. Chair, I asked the director and anybody else who is going to respond, just for a person who may not be familiar with all the acronyms, just to at least once, when you're starting, like I think you said the SSG or something, that I have no clue what you're speaking of, as well as the listening audience may not be familiar. And this committee is also important for the Caymanian people to know what we're speaking about. So I am a bit of a novice, I admit that. So to helping in our understanding, say what it means first, and then you can use the acronym every time after that, just for better dialogue. Through you, Mr. Chair, can the director say how many Caymanians have applied to be a lecturer in the last 4 years, Caymanian lecturers at the school?
From memory, through the chair, from memory, I believe 1.
Okay.
Which is probably 3 or 4 years ago.
What are the qualifications to become a lecturer at the school?
Well, we look for, obviously, competence in legal studies, so a first degree and a postgraduate degree. We look for teaching experience in terms of at the university level, law teaching experience. So that those are the 2 main criteria. We're bound, as you know, because of our affiliation with our UK affiliate partners, the University of Liverpool, for the Bachelor's of Law programme and the Master of Laws programme, and Oxford Brookes University now for the professional practice course qualification, the Diploma in Legal Practice. They have input in our recruitment process, and they clearly expect to see that we would be recruiting people with the same experience, the same sort of qualifications that they would be doing.
Okay, thank you. Through you, Mr. Chair, do you currently have any Caymanian lecturers there right now?
Well, if you include myself, yes.
Outside of yourself, obviously.
I don't believe we do, no. No. Yes, I mean, in terms of, thank you, AG, through the chair, particularly in relation to the professional practice course, we have a number of part-time lecturers, part-time tutors who come in to teach some of those courses. And really in reference to what we were talking about a few moments ago, we have a lot of skills that are taught on the professional practice course already, and a number of those skills are taught by lawyers in professional practice. I should say Deborah Barker, who was a long-term member of staff, my deputy director for many years, who now is a lawyer at Ogier. She has come in and she still teaches frequently on that course with us.
Okay, thank you. Through you, Mr. Chair, are you saying that majority of the Caymanians who do work through your school are the part-time ones, not the full-time ones?
Yes, correct.
Thank you. Through you, Mr. Chair, last question. I see that you have a particularly high turnover of lecturers there, particularly between the years of 2016, 2018. Is there a problem? Can you explain why the high turnover rate? Is there an issue?
Thank you for that question. I think the problem, honestly, is competitiveness of government salaries in relation to professionally qualified staff who can obtain much more lucrative positions in the private sector. Most of those people you referred to are now in private practice in the Cayman Islands.
Is there any measures you're taking to try to fix that? Maybe potential incentives or extra packages? I know there's a large competition with the private sector here, and it's a challenge that the civil service themselves are having as well. But as a result of recognizing that, is there any measures you're taking to try to, reduce that turnover from happening?
Well, through the chair, the measures that I think we have to accept that if a member of staff is very driven by financial gain, they will likely seek other opportunities when they become available to them locally. So we are perhaps taking a little bit more care in terms of recruitment as much as you can, in terms of trying to ensure that the people we are employing are committed academics who are used to the terms and conditions of academia in the UK and for whom employment in the Cayman Islands is certainly a step up financially. And we hope that by perhaps being careful in that regard more than simply going for high-flying academics who might have a whole string of professional qualifications and be attracted to the private sector, that we balance what we're looking for in terms of trying to find people who are more likely to stay long-term. But I should say a number of the staff who have moved in the period you mentioned to the private sector were long-term employees of the law school. Deborah Barker had been with me for 14, 15 years. Matt Rollinson, 10 or 12. Andrew Woodcock had been with us for 2 periods, in total probably 10 years. So they weren't people traditionally who were coming for a year or 2 and leaving.
Member for Northside.
To you, Mr. Chairman, to the Attorney General, Honorable AG, the Director, in my view, just gave a horrible description of the conditions under which the law school is operating in terms of accommodations. Has he made any proposal to you as to what the physical needs of the school are and whether we can get, it bears the name of a very prominent Caymanian. Maybe that Caymanian would build us a building just to put his name on it.
Thank you, Mr. Chair. Through you, yes, the director have been making ongoing representations about the accommodation. And as I said, there are sort of ongoing discussions about how best to accommodate that. The truth is that the original plan seemed to have fallen through, which was to have it annexed to as part of the original court building, the more expansive court building. Now that has changed. We need to come up with another plan as to how best to deal with the accommodation for the law school. But he has been making ongoing representations. Thank you.
All in favor?
Mr. Chairman, thank you. Mr. Chairman, couple things I would like to, from the director. Is the school at full student capacity, considering 78 or something of that nature, and the constraint you have with space?
Through the chair, thank you for that question. We're not at full capacity now, in the sense that we have limited facilities, but our classes are small. So our biggest classes would traditionally be the first year classes, and we probably have 25 or so students in the first year classes. Our biggest lecture room would take up to 35 students quite comfortably. So there isn't a problem in terms of restrictions or tightness of space in the lecture rooms. We have a separate seminar room as well, which is perfectly adequate. I think the issue really is perhaps we could do with some more space in terms of student reading rooms, that kind of thing.
And you mentioned you have arrangements now with Oxford Brooks. Okay. Do you look favorable at students of Oxford Brooks, alma mater, who has already gone through that regime and that university and now have degrees in other areas from that.
Through the chair, to my knowledge, we haven't had any students or staff members. We have one staff member who applied to us from Oxford Brookes who now is working with us. He worked with me many years ago, 20 years ago here, and came to us with a lot of experience. And he was the liaison with Oxford Brookes when we started this new association with them. So purely by chance, he took early retirement from Oxford Brookes University last year, and he was one of the members of staff we recruited last year. But we have in this individual someone who has huge amounts of experience, and someone who is not going to be going anywhere else. He's committed to the law school, and I think if he's allowed to stay until retirement age, he will do so. So he was, I think, an obvious choice and a very good choice. But apart from him, we've had no association with members of staff or students coming from either of our affiliate institutions.
No students, because there are a number of Caymanian students who have gone through Oxford Brookes from real early. I am personally very familiar with Oxford Brookes. On the compound, on the campus, probably once every 2 months for 5 years. Anyway, obviously they are not interested in, or the law school here may not recognize their other degrees then.
In terms of teaching positions with us? Or
No. To change professions.
Right.
Change discipline.
Right. I'm not aware of anyone from Oxford Brookes who has applied to us to attend law. It may be that they have, but I'm not aware of any.
Okay. On the matter of lecturers and the retention, can't we do non-compete clauses like all other law firms do?
Through the chair, I think that certainly would be helpful, because of course it involves the work permit process as well, that our former lecturers would have to go through that immigration process in order to be legally allowed to work in private practice. So it seems to me there are obvious ways in which that could be discouraged.
Yeah, I think maybe the Attorney General needs to look into non-compete clauses in these lecturers' contracts, because it seems like you're right. It's a step up coming here from being there in I'm talking about practice of law now. I ain't talking about teaching, but and that it's very attractive outside there, and you really can't blame them. Yeah. But if you're committed to teaching, then that's a profession. I hear it is described as a calling, but anybody can get called to something else if it's more attractive. I can tell you there are Oxford Brookes students who have no choice but to go back to Oxford Brookes now to do law. I'll leave it at that.
Member for Savannah.
Just a quick question. Is Mr. Razimich still attached to the law school?
Through the chair, he has no attachment to the law school to my knowledge.
All those in favor of LGA 3, Law Teaching and Publications, $1,401,728 in 2020 and $1,406,696 in 2021. Standing part of the schedule to the bill, please say aye. Aye. Those against? No. The ayes have it. Colleagues, it seems a very convenient time for us to take the lunch break. Member for Prospect.
Thank you, Mr. Chairman. Before we move on, I wish to make a point of order. as it relates to procedure, having been admonished by the Honorable Leader of the Opposition concerning the behavior and conduct of members. Mr. Chairman, I draw your specific attention to Standing Order 22, subsection 1, D and E, under the heading of questions. It reads, "The right to ask questions shall be subject to the following general rules, as to the interpretation of which the presiding officer shall be the sole judge." D and E, Mr. Chairman, specifically states, questions shall not be of excessive length. E, questions shall not contain argument, inference, opinion, imputation, or tendacious epithets, or ironical or offensive expressions. Now, given, Mr. Chairman, that for the purposes of these Finance Committee proceedings, you would be considered the presiding officer, I ask for a ruling on this point because the honorable member has inferred by name that I did something wrong or inconsistent with standing orders, which we are all obliged to follow as a junior member. Mr. Chairman.
Mr. Chairman, I need to respond to that one. It's an address to the chair about me. Well, he is correct about standing orders. My intervention with him was for him to stay in his place and know his place in here. It is your job to control our standing orders, not his.
Mr. Chairman, I strongly object to stay in my place. Mr. Chairman, we are all elected by the people. We all have equal rights, and whilst the member is absolutely correct as a senior member, he will not infer to me in a derogatory manner as if he is more privileged or has a greater right to be here than I do. That is offensive, Mr. Chairman, and I again ask you to make a ruling.
Yeah, and I will make a ruling. I will consider this over the lunch break, and we will get back and I'll
Mr. Chairman, I know my place. I must know my place. And my place is not to implement the standing orders. That's your place, sir. That is your job, sir. Nor it is not mine, nor is it his. And he must have more courtesy and respect for other members. And I will not withdraw that.
Let us take the lunch break. It is 12:25. We will return at 1:25.